Hope that's okay.
Good stuff. All right. Hi, everyone. We are live and welcome back to another week of immigration law updates with Joseph and Hall. We're going to talk to you today, as we always do. We're going to start with just kind of general updates on immigration, and then we will answer any questions that you have. Feel free to post your questions in the comment box, and we'll answer them throughout the presentation. So let's start with you, Ryland. Any updates this week on things that happened with immigration?
Yeah, so I wanted to talk about there were some updates to temporary protected status designations, which if you don't know what temporary protected status is, the Secretary of Homeland Security can designate foreign countries to have temporary protected status for temporary conditions in the country that would prevent a national that is already in the United States to be able to return safely. And this could be done for a civil war or an ongoing armed conflict of that nature, an environmental disaster like an earthquake or hurricane or even a pandemic, which is pretty appropriate nowadays, and other extraordinary conditions. And so this status, although it doesn't give anybody a green card or anything, it just makes the individual that is already present in the U.S. not removable from the U.S. And it gives them also the ability to apply for work authorization and for travel authorization. So it's meant to be a temporary thing. And it does not lead to lawful permanent status, but individuals with TPS can still apply for non-immigrant status or to adjust through an immigrant petition. And on Saturday, TPS was extended for another 18 months for Haiti. Haiti had already gotten TPS in 2010 following an earthquake that happened, a huge earthquake that sent the country into disarray. And it has been extended at various times since then, and it has yet again been extended on Saturday, and so it's supposed to be expiring in November of 2022. And so the latest extension was because of serious security concerns, social unrest, an increase in human rights abuses, crippling poverty, and lack of basic resources. And all of this, they said, was made worse by COVID-19 and the pandemic just layering on top of all of these already existing bad things happening in Haiti. And another cool one is that they also designated Burma as TPS on Tuesday this is not an extension, this is a new designation of TPS. And it's just like with Haiti, it's for 18 months. It ends on November 25th, 2022. And it's in response to the military coup that occurred there in February. And so that has led to a humanitarian crisis in the country with oppression and violence and large-scale human rights abuses. And so thankfully, anybody that has already been in the United States from Burma now has this TPS protection. And again, it is important to note that it only applies to individuals that are already in the United States. You can't, if you heard about this and then you come from Burma right now, it's not granted to you. So that is my TPS update.
Awesome. Anything to add to that, Aaron?
No, and you might have mentioned it, but the other thing about the Haiti designation is that, or extension, is that it's also a redesignation. So you only have to have been in the country from, I think, the day before it was announced, and you can qualify. You don't have to have been in the country as of the last designation, which is 2010. And so hopefully a lot more people are going to qualify through the new designation.
Yes, yeah, that is something that they did mention, that there were people that were now newly eligible in the United States for TPS.
Awesome. How about you, Aaron? Any updates from you on what's going on in the world of immigration?
I'll give a quick one. In U.S. immigration law, we have immigration detention. That means that the Department of Homeland Security locks people in jails during their immigration cases, and sometimes after their immigration cases. And it's a controversial thing, and I don't mind saying that I'm very much opposed to it. And the beginning of the Biden administration, I think they were down to about 14,000, maybe 13,000 people in immigration detention throughout the country. Since then, it has gone up. I think we're at somewhere from 20 to 22,000 under the Biden administration. So it's up somewhere between 30 and 50%. And that is largely due to people being detained after arriving at the southern border. So we are doing, actually, Ryland and I are doing a number of cases right now where we're trying to get people who've recently arrived out of immigration detention so that they can pursue their cases from outside of a jail. And so, it's disappointing that the Biden administration has actually increased the use of immigration detention. On the positive side, they just announced that 2 facilities would be closed for immigration detention because of medical neglect, one in Georgia and one, I think, in Massachusetts. So a couple of positive things, a little bit of negative things, but it's an issue that we continue to work on for our clients.
Well, I'll give a couple of updates as well. One of them is that ICE just announced yesterday that they're extending COVID I-9 flexibility for I-9s during COVID. So as you may know, when you apply for a job, the Immigration and Nationality Act requires you to prove that you are who you say you are, your identity, and that you have legitimate work authorization in the country. And an employer who completes the I-9 is required to physically examine the documents related to the person sitting across the table from them. But you can see how that would become very challenging in a remote work environment that COVID presents. And so ICE, realizing this, has given flexibility to employers to waive the requirement that they physically examine an actual document. However, that requirement only applies if your workforce is 100% remote. If there is anyone in your workforce that is in the office, then you must abide by the usual I-9 requirements that require actual investigation and physical inspection of the documents. But otherwise, if you're 100% remote, you can continue to abide by the agreement, the understanding that you can review the documents by fax, photocopy, or something like that. So that just came out yesterday. Another big announcement is additional H2b numbers. As you may be aware, there's a cap of 66,000 H2Bs available every year. H2B visas are temporary visas that are reserved for jobs that are peak load, seasonal, one-time occurrence, or intermittent. And so they're generally jobs that last less than a year. And the problem is there's only 66,000 of those visas available every year, and they split those visas into the spring, summer season and the fall, winter season. And they're used largely by resort industry, essential skilled jobs, landscaping, snow removal, those kind of jobs. The 33,000 visas that were available this year for the spring, summer, from April until September, were gone on day one. The very first day that they became available, the numbers were completely depleted. Congress has authorized the Department of Homeland Security to add additional numbers. And yesterday, we received final authorization from the Department of Homeland Security to file additional H2Bs, an additional 22,000 applications. So starting on the 25th, we now have 5 days to file those additional applications for those 22,000 numbers. So if you're an employer that relies on short-term labor, do feel free to reach out to us, and we'd be happy to talk you through what the requirements are for those H2Bs. Anything else? Any other updates from any of you before we start answering questions?
No, let's get to the questions.
Yeah.
All right. Let me start by taking down this banner here. All right, let's get to the questions here. First one is a question about Go. Did we find anything interesting in the administrative record? And have you seen their legal prioritization of November 2020? Aaron and Ryland, I know you're both in a deep dive into the Go documents, but what have we found?
Yes, I've seen that legal prioritization from November of 2020. It's interesting. The administrative record is really a history of the use of 212F, the statute 212F. And I think the first one to point this out was Zach New in our office, who pointed out that in their history, there's indication about how sparingly the government should use this authority, which is really interesting given how expansively they've decided to use it over the course of the last few years. So there's lots of interesting stuff. Like Jeff said, we're deep in it right now, and trying to get our response ready. For those who are asking about an update on the timeline, here's what we're looking at. We have a deadline of June 7th to file our cross motion for summary judgment and the response to the defendant's motion to dismiss and for summary judgment. From there, the defendants have a filing deadline to respond to us by June 24, and then we have our final deadline for briefing on July 2nd. The hearing is set for July 13th, so it's moving. That's the update.
All right, great news, Aaron. All right, another question. This one's about Milligan. Yeah, Gus, we thanks for tuning in, and thanks for sticking around through this whole litigation. I know that you and your sister are round one plaintiffs, and this is good news actually, because your sister's case has been stuck. It's one of the I think it is the only round one case that's remaining, and Montreal has been sort of stubborn about processing it. So it is good news that it's in transit. I see here that you're saying that every other NOA2 approved K1 case is being sent to Montreal. That's not necessarily a bad thing. I mean, what we've heard from the Department of State is they're going to process cases in line, right? First in, first out. I know that that's not true, but if all those cases from 2020 have been sent, presumably your sister's case would be one of the earlier ones. She's been pending for a long time. So good news that there's movement on it. Please continue to keep us updated on what's going on with that case as it gets to the consulate. And if you all have anything to add on these, please jump in. Oh, this is a great question. Are there any cases that have chances for consolidation? So let's do this in two parts. First of all, or three parts. What is consolidation? What does that mean? Are there any cases that have a chance of consolidation, and what would that look like? What would be the impact on plaintiffs in those cases?
Well, consolidation is when a court sees two cases on the same facts and legal issues, on the same basic facts and legal issues, and decides that it makes more sense for the court's efficiency to consider the cases at the same time. The way that it happens is usually there's a notice of related cases that's filed with the court, and then the court gets to decide whether they'll be heard together. Another way that it can happen is through a motion. As to whether there are chances for consolidation on any of the cases, I think that what this question might be getting at is that there is another attorney, I think Curtis Morrison and his team, looking to file a DV 2021 case, I think in the District of Columbia where Go is. And a lot of people are asking, is that going to affect Go or the deadline? We don't have control necessarily over whether a case is consolidated. Ultimately, it's going to be up to the court. But we will oppose vigorously any delay in the decision for our case, for our plaintiff's case, because we got this timeline based on an expedited basis based on the timeline for the fiscal year. And any delay is really upsetting to the parties in Go because we've already made this agreement. And so we would very much oppose any delay and would make the court aware of that.
Excellent. Okay. Next question is, we've already answered this one, about progress in the Go case. Yeah, we're due for our response and cross motion for summary judgment on June 7th. And that's really the final decision. I anticipate that the judge will set it for oral argument sometime after that. In fact, I think it is set for oral argument.
That's July 13th.
Yeah, it's set for oral argument on July 13th. And I would anticipate, given the fact that these cases are resolved in September, that Judge Mehta will turn around a pretty quick decision. But obviously, I can't promise that. All right, update on Milligan round 2, Manila round 2. Manila is deadlocked on not processing any cases. I mean, that's the update. There is no update. Manila is the one consulate that has basically said we are not doing K1s, and they're not saying that, they're just not processing them. And that is why we filed a separate mandamus against Manila itself, because even after the judge ruled that the proclamations are unlawful, Manila basically said, yeah, we're still not going to process. And so we filed a separate mandamus against Manila, Ramirez v. Blinken. So you should follow the progress of that case. That case has been assigned to the same U.S. attorney that's assigned to Milligan, Joe Carrilli. And the good news is that things are moving. So we have heard that, that things are moving on other cases. So it's good news when Joe's on the case because he does make phone calls. And so just stay tuned. All right, here's another thing about Consolidated. I think Aaron answered this. Consolidation is not something we can control, but we can object to based on the timeline that we've already set out. And if it disadvantages our plaintiffs, we have a right to object to it, and then the judge will decide whether the case should be consolidated. You remember that when we were in oral arguments the last time with Go, the judge actually asked if we should have oral arguments on the Gomez and Aker case with the Go case. So that tells you where the judge's mind is in terms of whether these are related issues. He thinks that they definitely are. So, if somebody filed a motion to consolidate, we sort of have a hint that Judge Mehta would be inclined to consolidate them. But we also know that he was trying to consolidate them for our court date, which is good news for us, right? So that's where we are. All right, update on the K1 Egypt lawsuit. It's filed. It is in the first 60 days where the government is now obligated to respond to our lawsuit in that first 60 days. It is our understanding, based on other lawsuits, that the government is going to litigate these cases, that they will file a motion to dismiss. We also already have that motion to dismiss. We've seen it in the other cases. We've seen it in Milligan. We've seen it in a number of cases. So we know the arguments that they're going to make. We've already briefed those arguments in the other cases, so we're prepared for them. One thing I do want to show you is one of the arguments we're going to make for the K1 Egypt lawsuit is, all of these cases are based on COVID, right? We need to protect our staff. We don't have staffing. And yet this is what we received from a plaintiff. Let's see, this is what we received from a plaintiff earlier this week from Manila. So let me just show you this. Can you all see the screen here?
Not yet.
You probably can't. I don't know if everyone else can see my screen here, but there we go, share. All right, so.
Whoa.
Sorry, whoa. I don't know what I just did there, but let me pull up this. That really messed things up, didn't it? I apologize for that. Stop sharing. Okay. We got this screenshot from the Secretary Blinken, where he said on Twitter, delighted to meet with the fantastic U.S. Embassy Cairo. And in the picture of him at the U.S. Embassy in Cairo, right in the middle of the embassy, there's no less than 100 people from the embassy standing around him, listening to him speak, and no one's wearing masks. So beautiful evidence for us of, the Cairo embassy clearly is not as concerned about COVID as they would make you believe. So sorry I couldn't share my screen. I'll figure that out before our next call. All right, here we go. I filed an I-129F K1 in September 2020. I'm past the processing time, still don't have an NOA2. She's from the UK, very interested in the London K1 mandamus lawsuit. Yes, if you're willing to do the lawsuit, you should go to any of our various websites. We have one at Joseph and Hall, which is immigrationissues.com, and you can go to the onboarding page for the London K1 mandamus lawsuit. We are at about 40 paid plaintiffs at this point, and if we get to 100 plaintiffs, then we will be filing that lawsuit. And I don't remember when the deadline for that one is. Do you remember, Aaron?
It looks like in the question he has it as I don't have the FAQ up in front of me, but he has it as
June 4th.
June 4th.
Okay. So, the only thing I would say is, yes, if you don't receive your NOA2, then you're not ripe for the lawsuit, because we're not suing USCIS. We're only suing the Department of State. So until your case is in the hands of Department of State, it would not be ripe for this lawsuit. Are we allowed to add the embassies as defendants to our lawsuit since DOS is throwing everything back to the embassy? Actually, yes. The embassies are constituent components of the Department of State, right? They are offices of the Department of State abroad. So when we sue the Department of State as an agency and sue the Secretary of Department of State, we are necessarily also suing the embassies. Now, that being said, the government is making this really interesting argument, and their argument in their motion to dismiss is that we didn't properly name the actual consular officer who is making the decision, and that we should have named the consular officer, not the Secretary of State. And they're sort of making this argument like the person that's actually in charge of the decision has more authority than his or her boss at the Secretary of State's office, right? And there are a number of courts that have basically rejected that argument. And so that's one of the arguments that they're reaching for, is that we didn't sue the right party. So your question is actually really relevant to what's going on in the case.
I wanted to jump in and say I double checked that date for the deadline, and it is June 4th for Ben's question for the London mandamus.
All right, Kinsley v. Blinken. Any update on this one, Aaron? Or
so the amended complaint bringing the India proclamation was submitted. I believe that the motion for summary judgment, we're looking at about 2 weeks out, if my memory serves correct. So that's the next step, and I know that we will be working on it, probably getting into it more next week.
Great. So again, we have another Curtis Morrison question. He plans to include a preliminary injunction motion with his DV 2021 case. How would that affect our strategy if the case is consolidated with Go?
I don't think it would affect our strategy. Even if his case is on a preliminary injunction track, it's going to be briefed back and forth, and it's not going to be heard ahead of July 13th. I mean, the case hasn't been filed yet, so I don't think that it affects our strategy in Go. Go should be on a faster track than that, and we're looking for a decision on the merits, not just a preliminary injunction.
Yeah, and I will say, this is not a criticism of Curtis. He's his own lawyer. He makes his own decisions, but we strategically decided not to do a preliminary injunction motion. What we decided to do is to do an expedited briefing to go directly to summary judgment, which is a final decision. A preliminary injunction is preliminary. It means like right now, while we're litigating this case, we want a decision on a particular issue. The problem with that is you basically have to prove your case at that level. You have to prove that you're likely to succeed on the merits, and you have to prove irreparable harm, right? Which is when we have a class like Go, which is made up of people that are sort of all over the place in timing. It's hard to say that there's irreparable harm for each individual plaintiff. That's a very high standard to make. If we just go for summary judgment, all we have to do is show that we win. We don't have to show irreparable harm to the plaintiffs. And so it's a lower standard. We're going to get a quicker hearing than he's going to get a decision. And so I agree with Aaron. Even if he files it, it shouldn't impact the case. I think this is the Blinken. If you all want to see the Blinken tweet, this is the one where he's around a bunch of people at the Cairo embassy. It's priceless. Judge Mehta doesn't want to hear the delaying. They'll be having a busy schedule after July 13th. That's true. He does have a busy schedule. He's handling a lot of the trials of the insurrectionists at the January 6th incident at the Capitol. And so that's obviously taking a lot of his time. That being said, he's very, very familiar with the issue of DV 2021, having dealt with it in Gomez. He knows that there's a September 30th deadline, and he's not gonna let that pass without having some sort of decision. So, as a federal judge, he gets it, and he will get a decision to you when it's appropriate. Can we transfer from one embassy to another, and how long will it take to transfer for diversity visas? What's the criteria and process?
So we've talked about this before, and isn't it? If an individual has citizenship in another country or some other actual tie to another country, then you would potentially be able to transfer your case to that other embassy. Is that right?
Yeah, that's most often the criteria that they put in place, but ultimately it's just up to the receiving embassy. And so a lot of the receiving embassies say, well, we'll consider it for citizens of our country or citizens of the country our embassy is sitting in, or people who reside here, but not for other people. But other embassies just say, oh, no, if we have the capacity, we'll take you. Or if there's a good reason for it, we'll take you. So the process is that you make the request first to the embassy you want to transfer to. And once they approve it, then the case can be transferred to the embassy. Then the embassy that already has it is notified, and it can be transferred. And we would just recommend that you keep good records of your requests and their responses, because right now, depending on where you're trying to transfer from and to, it's not really easy to get these transfers.
Yeah, the only other thing I would add to that is if your consulate is completely closed down, right? So Moscow, for example, there's simply no ability to get visas because they're closed. Moscow has been transferring visas, K1s, to other consulates, including Warsaw in Poland. So if you're from there, that's another option, or from a consulate that's completely shut down.
Can I just add in that it's been really interesting this last week because Moscow's public-facing communications say that they are closed down except for emergencies. Yet we've had plaintiffs from various lawsuits, not just one, that have been scheduled without emergency. And so we think, and I mean, our only thing we can think is that it's because of their status as plaintiffs in our various cases. So to the extent that they say they have zero capacity to process cases, it's just not true. We're seeing them process cases. It is possible for them to do.
That's right. I think we've already answered this question. Will we discuss specific consulates, Moscow, at a later stage? Yeah, I mean, as those things become relevant, right? When we're talking about things like Manila or Moscow, where they're just simply not processing visas, yes, those become relevant. But if consulates are processing some but not others, then it's hard to make an argument that the consulate itself is at fault, right? So in those cases, we're more looking at individual plaintiffs rather than the consulate as a whole. So we kind of do a mixture of both. For problem consulates, we point out the consulate. For consulates that are not problematic, we more focus on the cases that have been pending the longest. All right, Aaron, how long, or Ryland, how long once we get to a certain threshold of plaintiffs will it take to file a writ of mandamus?
Well, it depends on a number of things. First, how quickly do we get the necessary information from plaintiffs? Sometimes we need a declaration from each of them. Sometimes we need information about their case numbers or other information about communications with the consulate before we file everything. So as soon as we have that, then we can file. The other factors are, just we're human beings, and so if we hit that threshold and are able to take it on the same day or 2 days that we have another deadline in one of the cases, then it's going to be a couple of days before we can get to it. There's only so many hours in the day. In general, I think that I'll actually just look it up because I don't want to say something that's different than the FAQ. It says, I'm not seeing it right here. Sorry, I'm guessing that it says, I think that we're aiming for late June, early July as a date when it would be filed.
Yes, I think that's right. And Greg Siskin's office is going to handle the primary drafting on that one. Probably after her office will be drafting that mandamus as soon as we get to a threshold for plaintiffs. Can the judge disagree with the summary judgment request and ask for more evidence or information from parties?
Yes. Yeah, I mean, the judge can decide that a case is not proper for summary judgment because there's factual disputes that are material to the legal decision. So yes, the judge can do that.
Yeah, so basically how summary judgment works is both parties, the government and us, are submitting motions to the court. And the purposes of a summary judgment motion is basically you're saying to the judge, based on the facts that we've both presented, their facts and our facts, there's no real issue of material fact. We don't disagree about anything that's material. We agree on the major points in the case. And based on that agreement of facts, we should win. And the government says, based on that agreement of facts, we should win. They should win, right? And so there's these cross motions for summary judgment. And Aaron's, your question raises the right question that Aaron's answering, and that is that if there's a disagreement about evidence or a need for more evidence, then summary judgment's not appropriate at that point, right? The judge would say we need more discovery.
That said, the question was hypothetically speaking, and I think it is hypothetical because all parties here agree that there aren't going to be issues of material fact, and I feel strongly about that. I mean, I think the policies are what the policies are. The question is whether they're legal, and so I don't foresee that.
And having reviewed the record, we don't necessarily see anything in there that's glaringly missing, right?
No.
Yeah. So, okay, if we don't get to 100 plaintiffs, what's the minimum you would take to file the suit? Not going to make that decision. That's made really based on what our capacity is at the time, right? If we have capacity to take it for less, we will. If we don't, then we decline to take the lawsuit. J1 visas this summer. All I can tell you is this is one where I would file, I think you're best off filing an individual mandamus. I have real concerns about filing a big, massive group J1 mandamus. I think Aaron was the first to point out that, J1s are largely, if you're talking about interns or trainees, it's a little bit different maybe, but if you're talking about camp counselors, I have trouble seeing a judge saying that that's a universal priority and that other cases should be set aside for that. And I worry about a mass mandamus actually losing on irreparable harm. So my suggestion is that if you're going to do that, you file it on an individual basis, an individual mandamus, so you can point out the individual facts of your case and potentially not ruin it for other J1s. So that's my advice. Obviously, you do what you think, and our office is willing to take on your individual mandamus depending on the case. So if that's something you're interested in, call our office for a consult, 303-297-9171. All right. Can a lawyer intervene for transferring a case to another consulate?
Well, sure. The lawyer can communicate with the Department of State in their representation of an applicant. If the question is whether a lawyer like one of us can do it because you're represented in Go or one of the other cases, the answer is no. We don't. We haven't filed an entry of appearance for purposes of the processing of your visas with the Department of State, and we can't. We don't have the capacity to do it as part of our representation on the federal litigation.
But you can hire us to do it. You just need to hire us separately from the federal case. Yes, I mean, it is difficult to get a case moved. You've got to get a hotel room. You may have to quarantine in that country depending on what your country's rules are. So absolutely, this is all true. So, if you're going to transfer, take all of that into consideration before you make it. All right, Aaron, would you consider a new DV 2021 on different claims than Go?
Haven't considered it. Am not considering it. I would consider anything, but we don't have anything in the works.
And I'm not sure what the different claims would be, really. I mean, other than the ones we're making. So, we kind of have raised the issues of why DV 2021 needs to be decided now. It's the same kind of argument. So I'm not sure what arguments would be different or not relevant. And it would be unethical, frankly, for us to file a separate lawsuit on exactly the same claims when we've got one pending. Probably should consolidate. All right, I think we've come to the end of the questions. Is there anything else that you all want to add before we check out for this week?
I don't have anything else.
All right, well, just a reminder.
Thanks all for joining us.
Yeah, thanks for joining us. Just a reminder that we have our litigation update every Monday at 4 p.m. Mountain Time, 6 p.m. Eastern Time. That's a weekly call where we give updates on our litigation. And then this call is more of an immigration update that we do every week as well at this time. So tune in next week, same time, same channel, and we will see you all then.